Good afternoon, everyone. Welcome to the press room of the former Yugoslavish Tribunal, also known as the ICTY, now called the International Residual Mechanism for International Courts and Tribunals. We keep changing our name every so often, but in essence, this building housed many trials. This afternoon, I'm going to speak with you briefly about the role of Defense Counsel and the Defense Bar Association here previously at the ICTY. Now on behalf of the mechanism, which is the successor organ, so we now represent both branches, the Arusha and the Hague branch, which incorporate both the ICTY and the ICTR. As you can see from the slide behind me, hopefully, yes, my name is Dragan Iveitc. I am the current president of the ADC ICT, but everything that I say today is in my personal capacity. I intend to give you a brief introduction with just a few slides, and then I'll leave it up to you which direction we go by asking or answering questions that you may ask. So, to begin with, I'm an American lawyer. I started practicing here as an intern back, a long time ago, I think 1998. 1999, I came here as another staff member, and I've been at counsel since approximately 2002. There are many different defense counsel from all over the world that have come to practice at this tribunal and later the mechanism. We still call it the tribunal sometimes, those of us that have been here long enough. This institution, whatever you call it, operates on a hybrid system, meaning that it mixes parts of the common law or Anglo-Saxon legal tradition together with elements of the continental system. There are differences. We come from different jurisdictions. We use the same terminology, especially in the legal realm, but it has different meaning to us. It has different understanding to us depending on where we come from. So almost as a unwritten rule, ever since the beginning of the tribunal and now the mechanism, usually defense teams have members that are from both the continental and from the Anglo-Saxon common law system. When I say Anglo-Saxon common law, that's usually United Kingdom, Australia, the United States. Am I missing anyone? Jamaica, I think, also is common law. I'm not sure. There might be other countries that use the common law system. It's a more adversarial system as opposed to the European continental system, where the judge asks most of the questions and the parties work from a common file. The adversarial system is quite a bit different. So, my next slide. The association of which I'm president came about in 2002. And basically, we are the bar association for all attorneys that are licensed to practice before either the ICTY and now the mechanism. And how did that come about? That came about actually as a result of a request of the judges, chambers, of the first ICTY, because they wanted to have a collective body to deal with instead of individual lawyers. So for matters of efficiency and to ensure that the persons that were taking these very complicated, very large cases that were lasting many years, they wanted to make sure that the attorneys were qualified and more than just meeting the bare minimum of qualifications, that they were professional in their conduct towards the court or tribunal. So one might ask, first of all, what are the requisites to be a lawyer on the defense side before this institution or its predecessor institution? It used to be 5 years of experience, no criminal background, and you had to be licensed as a legal practitioner in a jurisdiction. It didn't matter which jurisdiction. Alternatively, you could be a law professor in another jurisdiction, and that time counted as well. As the years went by, the rule changed from 5 years experience to 7 years experience, where we're at right now. So to be a lawyer here, you need to have at least 7 years experience, be licensed in a home jurisdiction and in good standing, and not have a criminal record. I started off as being the youngest lawyer here when it was the 5-year rule. Obviously, I'm not that young anymore because I've been here quite some time, since 1998 as an intern, since 1999 in other capacities, and I think I already mentioned that since 2002 as a counsel. So, the association. You have our website up there. If you are interested in more information, we have a lot of information on the website. The Association of Defense Counsel is organized into several mandatory constitutional committees, such as the Executive Committee, 5 members. I'm the president, and there are 4 vice presidents. The Disciplinary Council, which operates separate and apart from the Executive Committee, so they could even bring disciplinary charges against someone on the Executive Committee. But more importantly, the Disciplinary Council can be approached by any lawyer who has questions about a particular scenario and wants an advisory opinion on how best to proceed in order not to run afoul of the rules. So our main job is to act as sort of as gatekeepers to make sure not only that qualified counsel are involved in these cases, but also to provide help and assistance to these counsel to continue to act to the best of their abilities in very difficult situations. We have a head of office. He is a full-time member. We are recognized and licensed under the laws of the Netherlands as a not-for-profit corporation. So we do follow all the corporate formalities. We do pay Dutch taxes, that is, say the association does. And then we have these other committees, which are not so-called the constitutional committees, but are still important. One of them that I think, especially since I see a few people who may be law students or interested in the practice of law out in this room, the Training Committee, which brings us to our next slide. Some of the activities which the association participates in addition to assisting attorneys, in addition to providing an internship program for defense teams that are practicing before cases at the mechanism or previously the tribunal. We also like to hold monthly advocacy trainings on various topics taught by well-known and respected practitioners in the realm, in the arena of international law, whose experience we then hope gets transferred to people. Every year we also hold a mock trial that's very popular, where particularly young lawyers or law students get the opportunity to act in a fictional scenario as either prosecutor or defense counsel, where they have a week-long of trainings intensively, and they have to file a motion, and they have to prepare for trial. And then on trial day, they're in a real courtroom here at this building in front of 3 real judges who treat them as if they are real litigants. And they have real clients who are sometimes not within their control. So they have to learn how to react as if a real lawyer would in a situation like that. The ADC also holds annual conferences on various topics. That is usually much larger of an event, so we hold it off-site, usually at the hotel that used to be called the Bel Air, that's now called the Marriott. Who knows what it'll be called next year. But our most recent conference in February had some participants from the Guantanamo Military Commission trials that are going on, and also had members of the Embassy of Colombia relating to the Colombian peace accords, and also had a panel on the Special Court for the Central African Republic. Among being recognized as the official bar association for this mechanism or this institution, the ADC ICT also is recognized as one of only 26 NGOs in the world to be part of the observer program at the Guantanamo Bay Military Commission trials, and we will be sending members over there to observe those proceedings in the coming months. So we have sort of a broader reach outside of this building, which is surprising to many of us because we, for a long time, didn't think that we would be around this long. Just like when I first came here, I had no idea I was going to be staying here as long as I did. I more or less have been in and out of the Netherlands, but calling the Netherlands home since 2006. And it was supposed to be on a short-term basis. So that's kind of how these trials go. They're much longer than traditional trials in other jurisdictions. I think I have, nope, I guess I don't have one more slide. Well, before we get to questions, comments, etc., a little bit of a background as to how the cases work. The prosecutor brings an indictment. Usually they've had many, many years to investigate. They've had larger staffs. First of all prosecution counsel are staff members of this institution, whatever its name may be. That means they get all rights, privileges, immunities, etc., which means they've been on salary for many years, and therefore there's some continuity in their case. On the defense side, we have to be on a list, and then when someone gets arrested, they pick who they want to be their lead counsel, and the lead counsel gets to constitute the rest of the team. And we therefore come into existence much later in the process. We get our information and documentation primarily from the prosecution and our own investigations, but we have a much shorter time frame to do that. And we're not, since most of the accused that have appeared here have been represented as indigent accused, meaning they cannot afford to provide for our services, most of the time our teams are paid on a flat fee system. That is to say, the more you work, the less you make type system for that defense. So unlike the prosecution, we're not salaried by this building or its predecessor institution. That often leads to, let's say, 30 prosecutors on a case that appear in court, maybe another 50 in the back that help with the case, whereas we usually get only 2 attorneys in the courtroom and 5 support staff behind the scenes that are paid for, and then we rely upon interns, that is to say volunteers, who also come from all around the world to work for free on cases just to gain experience. On one of my cases, because it was such a large case, we got special permission for myself to act, even though I was legal consultant, to act as the third counsel to appear in court. So again, whether it's 30 versus 3 or 30 versus 2, you can tell the prosecution has a much larger team. But we rely upon interns to do a lot of the work, and we have very trained and experienced counsel that have appeared in many cases. I myself, I think I've been involved in 6 cases at either the ICTY or the mechanism. I'm currently involved in 3 matters, technically. Yeah, I think 3, since post-conviction gets to be a little bit difficult to keep track of, because, of course, once someone goes to serve their sentence in another state, you still continue to represent them as an attorney. You just don't get paid for it. And you might not have contact with them, and they might not have regular need for counsel, but eventually they do. So I can say I have 3 active matters before the mechanism and 1 that is sort of half active. So that's quite a bit for one person in this institution. But that also means I have lots of experience, lots of real life stories. And so we have approximately 16 or so minutes left in the time allotted to us. So now I would ask if anyone has any questions. I'll try to answer them. If not, maybe I'll try and answer the closest that I can to that question, keeping in mind that oftentimes I am bound by confidentiality and things I know that I can't tell the rest of the world. So if I can't answer a question because of that, please don't hold it against me. But there are rules that I have to follow to stay in good standing with this institution. Okay, so who'd like to be the brave person to go first with a question? Any volunteers? There's one in the back over there.
Would you say that this is in some way particularly mentally taxing to defend individuals who are charged sometimes with gruesome acts or something? So would you say it's difficult mentally?
On whom?
On you to defend these individuals?
Yes. It's a very difficult, gruesome, tasking job, and that's but yet very many qualified practitioners still do it, even though we don't get paid the big dollars that we would if we did other types of law. For instance, cases can last 5 years. So if you can imagine, trial, I should say, it could last 5 years. So imagine getting up every morning to go into the courtroom on every day for 5 years, and you come home and then you open up another binder, read another set of statements, do some more research, have meetings, wake up and do the same thing the next day. Depending on the chamber and the speed and what other cases are involved, it can be even more grueling. I was involved in a case where for about 4 months, we had trial, that is to say, we were in the courtroom from 9 to 7 every day. And then again and again, 5 days a week. So yes, it is a very grueling and physically tasking endeavor. It's all the more harder because most of the people that come here are what I like to say notorious from the media, so that there is always I call it a predisposition to believing that they are guilty, which of course makes your job harder to find witnesses and evidence in favor of your defense theory, whatever that theory may be in a particular case. Depending on the questions, I can get back to that with some more statistics. There was a question in the front row, if I recall.
I just wanted to know a little bit more about the training program that you put forth.
Training program I put forth. So, we have two. Yeah. Basically, in this very same room, approximately every month, we have a training program. So it's we advertise it via various universities. We advertise it on our website. I can tell you the next training is going to be the 12th of October. That's a Saturday. And basically, we spend the entire day from 10:45 until 5 o'clock when they kick us out, talking about various legal topics. And the topics change, as do the speakers, depending on who's available. And the next one will be on command superior responsibility as it's treated in various international arenas. We've had lectures on DNA and forensic investigations. We just had an advocacy lecture actually yesterday, given by three of colleagues, three female practitioners who have a wealth of experience, one of whom did the whole, filled every office here, in that she was the ADC head of office, she was a defense intern, she was a defense legal consultant with rights of audience, i.e. able to appear in court, she was an amicus prosecutor, and she worked in chambers for the judges. So in essence, there's not an office in the building she didn't at one point in time have access to. And they did a very good presentation on pretrial matters, leading up to an indictment, leading up to an investigation, primarily focusing on the ICC because, of course, there's much less work still remaining at the mechanism. Okay, so that's one aspect. And then every year we have a mock trial, which is a much more intensive, much more expensive program. The trainings, if you're a member, I think it's something like 21 euros. If you're not a member, it's something like 30-something euros. You'd have to check the website to see, but we typically try to have them every month. Once in a while, if we have something else going on, we might miss a month. Like in February when we had the annual conference, we did not have a training because we just couldn't organize all of that. But it's open to anyone. So there are no minimum requirements. You don't have to be a member even. You just have to register, and we'll get security to get you in on a Saturday. And you get to hear and ask questions and sometimes participate in practical lessons. I saw a hand in the back there. Yeah.
I have a question. If you have any advice for law students, or if you can think back at your legal, your academic career or your professional career early on, if you can think back and see any points that prepared you for working on large cases. Yeah.
In my domestic career, I did not do a lot of criminal defense work. I did a lot of work on various types of cases. We had a very broad practice, so I was exposed to many different cases. And I had a lot of cases where there were a lot of documents involved. So you have to learn how to read and analyze documents quickly. Any opportunity like that helps you. Now, as for planning how to become an international law practitioner, even back when I was finishing law school, they were telling us there are no jobs for these people, so don't even bother trying. Yet here I am. When I started working, I was an intern in law school. And that lasted only 2 weeks. Client died. So then I didn't think my international career was going to last any longer. When I finished law school, the same attorneys approached me and said, we have another case in The Hague. How would you like to work at our home office doing everything but international law while we're here in The Hague on a part-time basis to keep the office running? And so I kind of became a part-time lawyer in Chicago. Then after a while, they said, well, you're here often enough, why don't we make you an associate member of the firm? So I became a full-time lawyer in the firm, dealing with all sorts of cases. I was outside counsel for General Motors Corporation. Couldn't get farther from criminal law. But because of my language skills, my research skills, and my writing skills, little by little I began helping on cases that were being done here by counsel, and then soon was sought after as counsel. The last several clients specifically asked for me, so even after I had left here and thought I was going back to that world, I ended up coming back. The point of that story is take advantage of any opportunity you are given, because there is no one right path to get here. Everyone I've known has taken different paths and have ended up here and either stayed here or gone elsewhere. So take advantage of any opportunity that gets you experience, because most jobs in the international law arena are based upon your years of experience after you are licensed as an attorney. That's the key. But nowadays I see a lot of people that need internships, pupilages, or other things before they can even become a licensed attorney. You know, most of my interns that I've had, their CVs would have put mine to shame when I was their age. Let's put it that way. So things have changed. But I would say take advantage of any opportunity you can to get experience, and then eventually to get licensed in a jurisdiction, so the clock starts ticking on your whether you can apply for a P1, a P2, or a P3 position. I think for P1 it's 3 years, P2 it's 5 years, P4 it's 7 years. So if your aim is to do what I'm doing now, you have to start and have a long-term kind of vision, if that makes sense. Okay, I think I missed a hand somewhere. Was there one? I can't tell from the light. So yeah, that's what I thought.
Where does the funding for the ADC come from? Is it from the United Nations as well?
No, it does not. The ADC is a self-funded entity. The member lawyers of the ADC pay dues. Therefore, the dues go towards keeping up the organization, and whatever we charge for events covers our costs, and whatever minimal profit we make also goes back into the organization. We are not funded by the United Nations. We are like I said, a standalone Dutch not-for-profit that happens to have an office at the front of this building, but we are technically not an official we are an official bar association, but we're not funded by the UN.
Then how do you make a living if the money comes from yourselves?
The ADC does not really make a living. We basically just are there to do a function. Pardon?
The lawyers in the ADC?
The lawyers, there's two types of cases. Probably should have spent more time on that. One case are privately represented individuals. Those are individuals where usually a state pays for lawyers to represent somebody. Okay? And we don't know how much they charge, how much they make. Then if you are considered to be an indigent accused that can't afford lawyers, the UN does pay for lawyers, depending on the criterion of how complex the case is, level 1, 2, or 3, then that defense team is funded by the UN. So the lawyers are funded, the association, that's why I keep making the distinction of the association. So for instance, like I said, on one of my bigger cases, which was the level 3 case, you are entitled to have 2 lawyers, and you are entitled to have, I think it's 5 support staff, but at fixed rates, at fixed flat fee rates. It used to be like, the hourly used to be for co-counsel 82 euros an hour. Back in the States, 300, 400 an hour was what my rate was. But now, when it's a flat fee system, you get a flat fee for the entire team. And so if you work 10 hours or if you work 254 hours, you get the same flat fee. So, the hourly is really kind of a non-descriptive method of figuring out what the actual compensation is. Okay?